Hello there. Today, we are going to discuss Republic Act No. 8550, as amended by Republic Act No. 10654. The Republic Act No. 8550 was approved on February 25, 1998, by then Philippine President Fidel V. Ramos. It preceded Presidential Decree No. 704 of the Philippine Fisheries Code of 1975. RA 8550 is commonly known as the Philippine Fisheries Code of 1998. After years of its implementation, there is a need to amend some provisions of the Fisheries Code to effectively manage the country's aquatic and marine resources from further destruction. Illegal, unregulated and unreported IUU fishing threatens effective management and conservation of these resources. IUU fishing covers a broad range of fishing activities, such as 1. Illegal fishing covers not only fishing in violations of existing fisheries laws, but also fishing in a foreign state without a permit or license. 2. Unreported fishing covers fishing activities that are unreported or misreported to authorities. And 3. Unregulated fishing refers to fishing in areas under Regional Fishery Management Organization by vessels without nationality. Most of these activities were not regulated under the Republic Act 8550 or the Fisheries Code. The United Nations Food and Agriculture Organization or FAO says IUU fishing can lead to collapse of fishery and ruin efforts in reviving depleted fish population. According to a study published in March 2016, the average catch of a Filipino municipal fisherfolk is 13.5 kilograms per day. Municipal fisherfolks often catch low-val species, such as round scads and sardines, and its value is hardly enough to pay for a fisher and his family's daily needs. Furthermore, fisherfolks do not fish every day, with only about 192 fishing days or 53% in a year, depending on weather conditions and access to operational expenses. The issue on the IUU fishing is not a new problem in the fisheries industry. In the late 1990s, there were already calls by international organizations and governments to combat IUU fishing. FAO's Committee on Fisheries subsequently crafted the International Plan of Action to prevent, deter, and eliminate illegal, unreported, and unregulated fishing, or IPOA.U.U. By 2001, the United Nations urged all states to comply with IPOA-IUU by March 2004. But these were unheralded in the Philippines. Under the Fisheries Code, licensing was merely used for revenue generation and statistics, rather than to control fishing effort and manage fisheries resources. Unregulated and unreported fishing were not even prohibited by the authorities. With the onset of climate change, warm temperature and ocean acidification, the ocean and aquatic ecosystems become even more vulnerable, and require more protection for these ecosystems to adapt and build resiliency, both for people and the planet. It took a yellow card warning from the European Union or EU, for possible trade sanctions, for the Philippines to fortify its fisheries code through the swift amendments under Republic Act 10654. Through this new and stronger law, the government puts in place stronger harvest control rules, repertorial requirements, vessel monitoring misuse, stiffer penalties for violations, citizen suit, anti-strategic lawsuit against public participation or SLAPP, and other regulations to sustain fisheries resources and ensure food security. What are the salient features of the amendments in RA 8550, in combating illegal, unreported and unregulated fishing? The following are the salient features of the amendments. The first salient feature is determination of the area's carrying capacity, and the number of fishing vessels allowed to operate based on reference points, and harvest control rules. Reference point is a set of indicators that describes the level of exploitation, status of the fisheries or biological characteristics used as standards for regulatory purposes. On the other hand, harvest control rules are specific actions, in a form of regulatory measures, that will make sure that target reference point is achieved, and the limit reference point is avoided. Examples of regulatory reference measures include limitation in license issuance, limits on mesh size, or declaration of closed season. The second salient feature is repertorial requirements. Commercial fishing vessels are required to keep a daily record of fish catch, spoilage, fishing effort, and other information on catch and disposal, which should follow the form of a catch documentation system to be crafted by the Department of Agriculture, Bureau of Fisheries and Aquatic Resources or DABFAR. This information must be reported to the DABFAR, otherwise the owner, operator or officers of the vessel can be penalized. The third salient feature is monitoring, control and surveillance or MCS system. Municipal, commercial, and distant water fishing vessels, are required to comply with vessel monitoring measures to be established by the DA. These vessels must have Vessel Monitoring System or VMS to track and monitor the position, course and speed of the vessels at any given time for the purpose of managing fishing effort and for traceability. The fourth salient feature is citizen suit, a legal remedy integrated in the law to promote the citizen's right to participate in decision-making, enhance civil and political rights, and ensure implementation of the law. The fifth salient feature is the strategic lawsuit against public participation or SLAPP measure. This means that enforcers and the citizens who push for fishery reforms can use the defense of SLAPP in cases filed to purposely harass, chill or vex them. The sixth salient feature is additional prohibited acts. A total of 21 prohibited acts were added to the Fisheries Code, such as unregulated and unreported fishing. The existing prohibited acts were also expanded or modified. For example, illegal fishing now covers violations of Regional Fisheries Management Organization resolutions, and laws of other coastal states. The seventh salient feature is harsher penalties for violations. Fines could reach up to 90 million pesos for unreported fishing, for example. Under RA 8550, penalties for unauthorized fishing is fined up to 10,000 pesos only, and confiscation of catch and gears. Under the amendments, the fine could reach up to 10 million pesos, and the penalty now includes imprisonment of 6 months, and confiscation of catch and gears. The last salient feature is accept administrative actions. All cases involving violations of the Fisheries Code and its amendment are governed by the rules and procedure for environmental cases. What are the important information related to the amended Fisheries Code? Republic Act No. 10654 emanated from House of Representatives, through House Bill No. 4536, and Senate Bill No. 2414, which was passed on December 1, 2014. It lapsed into law on February 27, 2015, and became effective on March 24, 2015. However, the implementing rules and regulations or IRR became effective on October 10, 2015. The law is composed of 10 chapters, and 167 sections. What is the complete title of this law? According to Section 1, this law shall be known as the Philippine Fisheries Code of 1998, as amended by Republic Act No. 10654, entitled An Act to Prevent, Deter, and Eliminate Illegal, Unreported, and Unregulated Fishing. This is simply known as the Code. What is the declaration of policy related to the Code? Section 2 states that it is the policy of the state to 1. Achieve food security. 2. Limit access to the fishery and aquatic resources of the Philippines. 3. Ensure the rational and sustainable development, management and conservation of the fishery and aquatic resources in Philippine waters, including the Exclusive Economic Zone or EEZ, and in the adjacent high seas. 4. Protect the rights of fisherfolks, in the preferential use of the municipal waters. 5. Provide support to the fishery sector, primarily to the municipal fisherfolk. 6. Adopt the precautionary principle and manage fishery and aquatic resources, consistent with the concept of an ecosystem-based approach to fisheries management, and integrated coastal area management. And 9. Grant the private sector the privilege to utilize fishery resources, under license or permits. What is the objectives of the fishery section? The state shall also ensure the attainment of the following objectives of the fishery sector. 1. Conservation, protection and sustained management of the country's fishery and aquatic resources. 2. Poverty alleviation, and the provision of supplementary livelihood among municipal fisherfolk. 3. Improvement of productivity of aquaculture, within ecological limits. 4. Optional utilization of offshore and deep-sea resources. And 5. Upgrading of post-harvest technology. What is the scope of application of the Fisheries Code and its amendments? The provisions of this code shall be enforced in 1. All Philippine waters, including other waters over which the Philippines has sovereignty and jurisdiction, and the country's 200 nautical mile exclusive economic zone or EEZ, and continental shelf. 2. All aquatic and fishery resources, whether inland, coastal or offshore fishing areas, including, but not limited to, fish ponds, fish pens and cages. 3. All lands devoted to aquaculture, or businesses and activities relating to fishery, whether private or public lands. And 4. All Philippine-flagged fishing vessels operating in areas governed by a regional fisheries management organization, in the high seas, or in waters of other coastal states. In terms of jurisdiction, the BFAR have responsibility and jurisdiction in the management, conservation, development, protection, utilization, and disposition of all fisheries and aquatic resources of the country, and all Philippine-flagged fishing vessels operating in areas governed by a regional fisheries management organization, in the national waters which is more than 15 kilometers from shoreline, high seas, or in waters of other coastal states. On the other hand, local government units or LGU have responsibility and jurisdiction over municipal waters. The L.G.US may be assisted by BFAR, FARMCs, and other government agencies concerned, in the development, conservation, protection, utilization and management of fisheries and aquatic resources. What are the uses of Philippine waters? The use and exploitation of the fishery and aquatic resources in Philippine waters shall be reserved exclusively to Filipinos. Also, research and survey activities may be allowed under strict regulations, for purely research, scientific, technological and educational purposes that would also benefit Filipino citizens. Who issues permits and sets fees on vessel license and fishery charges? The DA, through the BFAR, sets the following fees and fishery charges. 1. Rentals for fishpond areas covered by the Fishpond Lease Agreement, or FLA. 2. License fees for commercial fishing vessel licenses or CFVL. 3. Fees and other fishery charges, and 4. Issues the license or permit for fishing gear and its accessories, and other fishery activities beyond municipal waters. The City of Municipal Local Government Unit or LGU, set FES and other fishery charges, and issues the licenses or permit for fishing gear and its accessories, and other fisheries activities within the municipal waters. The license fees of fishery activities within municipal waters are determined in consultation with the Fisheries and Aquatic Resources Management Councils or FARMC. The FARMC may also recommend the appropriate license fees that will be imposed. In terms of protected areas, the Department of Environment and Natural Resources or DENR sets the fees, while the Protected Area Management Board issues the permit for fishing and other activities within the protected area. Is there a limit on the issuance of licenses and permits? The answer is yes. The BFAR determines the number of licenses and permit for fishery activities subject to harvest control rules and reference points. Likewise, the LGU and special management bodies are granted authority to set the limits, in coordination with the BFAR. Who can access to fishery resources? The department shall issue licenses and permits for the conduct of fishery activities, subject to harvest control rules and reference points, as determined by scientific studies or best available evidence. Resource users in the local communities adjacent, or nearest to the municipal waters, are given preference in the issuance of licenses and permits, in conducting fishery activities. Existing CFVL holders have also priority rights in allocation of licenses, as long as they have no record of violation on the terms and conditions of their licenses, subject to the carrying capacity of the ocean. Section 8 of the Code is about the harvest control rules and reference points. The Secretary may establish reference points and harvest control rules in a fishery management area or for a fishery. Once the limit reference point is reached, the following harvest control measures shall be implemented. 1. Limitation on fishing effort. The fishing effort per fishing ground or fishery management area shall be maintained at existing levels, and no additional new licenses shall be issued. 2. Determination of priority access for renewal of licenses. Licensees of CFVL who have been timely and consistently submitting catch reports shall have priority access to the fishing ground through the renewal of their licenses. However, licenses shall not be renewed if the licensees have been found guilty by a court of a serious violation as defined in this code. 3. Declaration of a closed season. A closed season, either spatial, temporal or by gear or fishing method, may be declared as appropriate. 4. Reduction by attrition. As an extreme measure when the resource is at its critical level, decommissioned vessels shall not be replaced, and 5 other measures may be adopted, when necessary. What is a closed season? A closed season is a period when the taking of specified fishery species by a specified fishing gear, or specific fisheries activities, is prohibited in a specified area in Philippine waters. WHO can declare a closed season? The following can declare a closed season. 1. The Secretary may declare a closed season, through public notice in at least 2 newspapers of general circulation or in public service announcements. 2. The LGU in consultation with the FARMC, for conservation purposes. The FARMCs may also recommend closed seasons, in municipal waters, fisheries management, and other areas reserved for the use of municipal fisherfolks. Section 11 of the Code is about the protection of rare, threatened, and endangered species. The Department shall declare closed seasons, and take conservation and rehabilitation measures for rare, threatened and endangered species, as it may determine, and shall ban the fishing and or taking of rare, threatened and or endangered species, including their eggs/offspring as identified by existing laws, in concurrence with concerned government agencies. What is an environmental impact statement? The Environmental Impact Statement or EIS, is a government document that outlines the impact of a proposed project on its surrounding environment. According to Section 12, all government agencies and private corporations, firms and entities who intend to undertake activities or projects, which will affect the quality of the environment, shall be required to prepare a detailed EIS, prior to undertaking such development activity. What is Environmental Compliance Certificate? The Environmental Compliance Certificate or ECC, refers to the document issued by the DENRE.M.B, that allows a proposed project to proceed to the next stage of project planning, which is the acquisition of approvals from other government agencies and LGUs, after which the project can start implementation. Section 13 of the Code states that all environmental impact statements shall be submitted to the DENR for review and evaluation. No persons, natural or juridical, shall undertake any development project without first securing an ECC from the Secretary of the DENR. Section 14 of the Code is about the monitoring, control and surveillance or MCS of fishing in all Philippine waters and Philippine-flagged distant water fishing vessels. A monitoring, control and surveillance system shall be established by the Department in coordination with LGUs, FARMCs, the private sector and other agencies concerned, to ensure that the fisheries and aquatic resources in Philippine waters are judiciously and wisely utilized and managed on a sustainable basis, and conserved for the benefit and enjoyment exclusively of Filipino citizens. The MCS system shall encompass all Philippine-flagged fishing vessels, regardless of fishing area and final destination of catch. What is an auxiliary invoice? An auxiliary invoice is a document issued by LGU, for a permit prior to the transport of fishery products from the point of origin to their point of destination upon payment of the fee prescribed by existing ordinance. What does the law says about auxiliary invoice? Section 15 states that all fish and fishery products must have an auxiliary invoice to be issued by the LGU or their duly authorized representatives, prior to their transport from their point of origin to their point of destination. Who has the jurisdiction over municipal waters? The city or municipal LGU has jurisdiction over municipal waters. They are responsible to do the following. 1. Manage, conserve, develop, and protect fishery or aquatic resources within the municipal waters, in consultation with the FARMC. 2. Enact a municipal fisheries ordinance, in consultation with the FARMC. 3. Enforce all fishery laws, rules and regulations, and fishery ordinances. What areas are included in municipal waters? Streams, lakes, and other inland bodies of waters within the municipality, and marine waters included between two lines drawn perpendicular to the general coastline, from points where the boundary lines of the municipality touch the sea at low tide, and a third line parallel with the general coastline, including offshore islands, and 15 kilometers from such coastline. How would two municipalities situated on opposite shores determine their municipal waters if there is less than 30 km of marine waters between them? Where two municipalities are so situated on opposite shores that there is less than 30 kilometers of marine waters between them, the third line will be equally distant from opposite shore of the respective municipalities. Who will mediate when overlapping boundaries of municipal waters results to resource use conflict? The concerned city or municipal governments must allow mediation by BFAR, in consultation with the national FARMC, local FARMC, and stakeholders, to resolve the conflict. What are excluded from municipal waters? Marine waters, seascapes, fishing reserves, streams, lakes, inland bodies of water and tidal waters within the municipality which are included within the protected areas as defined under the Republic Act No. 7586, National Integrated Protected Areas System or NIPAS Act. What is the responsibility of the city or municipality over waters covered by the National Integrated Protected Areas System? The city or municipality participates in protected area management through representations in the Protected Area Management Board, or PAMB. Moreover, the city or municipality are also enforcers of fisheries and other environmental laws in protected areas within their territory, to promote general welfare. What should a municipal fisheries ordinance cover? A basic municipal fisheries ordinance must cover the following. 1. Delineation of the boundaries of the municipal waters. 2. Rules and regulations on licensing and permits for other fisheries activities, including the number of licenses and permits that may be issued, in accordance with harvest control rules and reference points, that may be adopted for the municipal waters. Who are allowed to use the municipal waters for fishery activities? Registered fisherfolks and their organizations can use the municipal waters for all fishery activities. Is commercial fishing allowed within municipal waters? Yes, provided that several conditions by concerned LGU are met. Also, not all commercial fishing activities are allowed in the municipal waters. When is commercial fishing allowed within municipal waters? The LGU may allow commercial fishing within municipal waters through an ordinance, under the following conditions. First, only small fond medium-scale commercial fishing vessels, with 3.1 to 150 gross tonnage capacity, are allowed to fish in municipal waters. Second, the vessels can only operate within 10.1 to 15 kilometers area from the shoreline. Third, no commercial fishing in depths less than 7 fathoms or 13 meters. Fourth, the methods and gears to be used in fishing must not be illegal. Fifth, prior consultation, through public hearing, with the municipal or city FARMC has been conducted. And lastly, the applicant vessel, including the ship owner, employer, captain and crew, have been certified by the appropriate agency, as not having violated this code, environmental laws, and other related laws. However, the LGU are required to establish harvest control rules within the municipal waters. Consequently, commercial fishing in municipal waters is subject to overall carrying capacity of the area. When it is exceeded, fishing efforts may be limited or issuance of new licenses may be stopped. How is priority access among fisherfolks determined? The Registry of Municipal Fisherfolk is used in identifying priority access among municipal fisherfolks to fish or to engage in fisheries. The FARMC must also submit to the LGU the list of priorities for its consideration. What are the rights and benefits of municipal fisherfolks and fish workers? Municipal fisherfolks and fish workers have the following rights and benefits. 1. Resident municipal fisherfolks and their organizations enjoy priority to use municipal and demarcated fishery areas of the municipality. 2. The department and the LGU must provide support to municipal fisherfolks through technology and research, credit, production and marketing assistance and other services. And 3. Fish workers are entitled to privileges under the Labor Code, Social Security System, and other benefits under other laws. Fish workers, on board any fishing vessels, engaged in fishing operations, are covered by the Philippine Labor Code. What does the code says about commercial fisheries activities in the Philippines? No person shall operate a commercial fishing vessel, pearl fishing vessel or fishing vessel for scientific, research or educational purposes, or engage in any fishery activity, or seek employment as a fish worker, or pearl diver without first securing a license from the department. However, no such license shall be required of a fishing vessel engaged in scientific, research, or educational purposes within Philippine waters, and pursuant to an international agreement of which the Philippines is a signatory. Who are responsible for the registration of fishing vessels and fishing gears? In municipal waters, the LGU have the responsibility in registering and licensing fishing gears, and fishing vessels less than 3 gross tonnage. Licenses are renewed every year. In terms of registering fishing gears and fishing vessels more than 3 gross tonnage, the Bureau of Fisheries and Aquatic Resources is the responsible agency. The licenses are renewed every 3 years. What are the guidelines in the application for commercial fishing vessel license? Subject to compliance with the provision under Fisheries Code as amended, including the installation of vessel monitoring measures, the conditions stated in the license, and the rules and regulations that may be promulgated by the DA. The BFAR shall issue to qualified commercial fishing vessel licenses or commercial gear licenses, to engage in commercial fishing in fishing areas beyond municipal waters. Skiff boats are exempted from the license requirement. What does the code says about distant water fishing? Fishing vessels of Philippine registry may engage in distant water, provided that they comply with the following requirements. 1. Safety, manning and other requirements of the Philippine Coast Guard, Maritime Industry Authority, and other agencies concerned. 2. Secure a fishing permit, gear license and other clearances from the DA. 3. Comply with the monitoring, control and surveillance requirements, conservation and management measures, and fishing access conditions of the Department, the RFMO, or other coastal states. Are fish caught through distant water fishing subject to import taxes? The answer is no. Fish caught by fishing vessels of Philippine registry are considered as caught in Philippine waters, and therefore not subject to import duties and taxes, when landed in designated fish landings and fish ports in the Philippines. Are commercial fishing vessels required to have medical supplies and life-saving devices on board? Yes. All fishing vessels shall be provided with adequate medical supplies and life-saving devices. Also, a fishing vessel of 20 gross tonnage or more shall have as a member of its crew a person qualified as a first aider, duly certified by the Philippine National Red Cross. What does the code says about repertorial requirements? Each commercial fishing vessel are required to keep the following reports. 1. A daily record of fish catch and spoilage. 2. Landing points. 3. Quantity and value of fish caught, and 4. Fish offloaded for transshipment, sale and / or other disposal. Detailed information shall be duly certified by the vessel's captain, and transmitted to BFAR. What is a CDS? CDS refers to Catch Documentation System, which must be followed by commercial fishing vessels in recording fish catch. Subsistence fishers are exempted from Catch Documentation System. What is transshipment? Transshipment refers to the transfer of all, or any fish or fishery product from one fishing vessel to another. When is transshipment authorization required? Transshipment by Philippine-flagged fishing vessels in waters beyond national jurisdiction requires a transshipment authorization by BFAR. When is transshipment authorization required? Transshipment authorization is not required, in the following instances. 1. In a group seining or other net, to hatch operation involving the transfer of fish, from the fishing net of a catcher vessel directly to the hatch of the carrier vessel, and 2. In cases of emergency, when there is a need to save lives or property, in which case, a mere notification will suffice. Section 45 is about disposition of public lands for fishery purposes. It states that all public lands such as tidal swamps, mangroves, marshes, foreshore lands and ponds suitable for fishery operations, shall not be disposed or alienated. What does the code says about lease of fish ponds? Fish pond lease to qualified persons, and fisherfolk organizations / cooperatives, shall be subject to the following conditions. 1. Areas leased for fish pond purposes, shall not be more than 50 hectares for individuals, and 250 hectares for corporations or fisherfolk organizations. 2. The lease shall be valid for 25 years and renewable every 25 years. In case the lessee dies, his spouse and/or children, as his heirs, shall have preemptive rights to the unexpired term of his fish pond lease agreement or FLA, subject to the same terms and conditions provided, and the said heirs are qualified. 3. Lease rates shall be determined by DA, and all fees collected shall be remitted to National Fisheries Research and Development Institute, and other qualified research institutions, to be used for aquaculture research development. 4. Leased area shall be developed, and producing on a commercial scale within 3 years from the approval of FLA, provided that areas not fully producing within 5 years from the date of FLA approval shall automatically revert to the public domain for reforestation. 5. The fish pond shall not be subleased, in whole or in part, and failure to comply with this provision shall mean cancellation of FLA. 6. Transfer or assignment of rights to FLA shall be allowed only upon prior written approval of the DA. 7. The lessee shall undertake reforestation for river banks, bays, streams and seashore fronting the dike of his fish pond, subject to the rules and regulations to be promulgated thereon, and 8. The lessee shall provide facilities that will minimize environmental pollution, including settling ponds, reservoirs, etc. Failure to comply with this provision shall mean cancellation of Florida. What does the code says about abandoned, undeveloped or underutilized fish ponds? The DENR, in coordination with the BFAR, LGU, other concerned agencies and FARMCS, shall determine which abandoned, Undeveloped or underutilized fish ponds covered by FLA can be reverted to their original mangrove state, and after having made such determination shall take all steps necessary to restore such areas in their original mangrove state. Section 55 tackles about non-obstruction to navigation. No structure shall be constructed that will obstruct the free navigation in any stream, river, lakes or bays flowing through or adjoining the fish pens, fish cages, fish traps, and fish ponds, or impede the flow of the tide to and from the area. Any construction made in violation hereof shall be removed upon the order of the DA in coordination with the other government agencies concerned, at the expense of the lessee, or occupants thereof, whenever applicable. Similarly, no structure shall be constructed that will obstruct any defined migration path of migratory fish species, such as in river mouths and estuaries, within a distance determined by the concerned LGU, consultation with and upon the recommendation of the FARMCs. What does the code says about registration of fish hatcheries and private fish ponds, etc.? All fish hatcheries, fish breeding facilities and private fish ponds must be registered with the LGU, which shall prescribe minimum standards for such facilities in consultation with the DA. A yearly inventory of all fish ponds, fish pens and fish cages, whether in public or private lands, shall be conducted by DA. All fish pond, fish pen and fish cage operators shall annually report to the DA the type of species and volume of production in areas devoted to aquaculture. In terms of establishment of post-harvest facilities for fishing communities, the LGUs shall coordinate with the private sector and other concerned agencies and FARMCs in the establishment of post-harvest facilities for fishing landing sites, fish ports, ice plants and cold storage and other fish processing establishments, to serve primarily the needs of municipal fisherfolk. Are all post-harvest facilities need to be registered and have a license? Yes. All post-harvest facilities, such as fish processing plants, ice plants, and cold storages, fish ports/landings and other fishery business establishments, must register with and be licensed by the LGUs, which shall prescribe minimum standards for such facilities in consultation with the department. What does the code says about the importation and exportation of fishery products? 1. Export of fishery products shall be regulated whenever such exportation affects domestic food security and production. The exportation of live fish shall be prohibited, except those which are hatched or propagated in accredited hatcheries and ponds. 2. To protect and maintain the local biodiversity or ensure the sufficiency of domestic supply, spawners, breeders, eggs and fry of bangus, prawn and other endemic species, shall not be exported, or caused to be exported by any person. 3. Fishery products may be imported only when the importation has been certified as necessary by the department, in consultation with the FARMC, and all the requirements of this code, and all existing rules and regulations have been complied with. Fish imports for canning/processing purposes only may be allowed without the necessary certification. And 4. No person shall import and/or export fishery products of whatever size, stage or form for any purpose. The Bureau of Fisheries and Aquatic Resources, or BFAR, is reconstituted as a line bureau under the Department of Agriculture. There have been several calls, which pushes for the creation of a separate department to cater the fisheries and aquatic resources of the country, but are still not being materialized. The proposed department will be called as Department of Fisheries and Aquatic Resources. The BFAR has several functions, including 1. Issue licenses for the operation of commercial fishing vessels. 2. Issue identification cards free of charge to fish workers engaged in commercial fishing. 3. Monitor and review joint fishing agreements between Filipino citizens and foreigners who conduct fishing activities in international waters, and ensure that such agreements are not contrary to Philippine commitment under international treaties and convention on fishing in the high seas. 4. Provide extensive development support services in all aspects of fisheries production, processing and marketing. 5. Provide advisory services and technical assistance on the improvement of quality of fish from the time it is caught. 6. Assist the LGUs in developing their technical capability in the development, management, regulation, conservation and protection of the fishery resources. 7. Implement an inspection system for import and export of fishery and aquatic products and fish processing establishments, consistent with international standards to ensure product quality and safety. 8. Enforce all laws, formulate and enforce all rules and regulations governing the conservation and management of fishery resources, except in municipal waters, and to settle conflicts of resource use and allocation in consultation with FARMC, LGUs and local FARMCs. 9. Train, designate and deploy fisheries observers in Philippine-flagged fishing vessels, engaged in commercial fishing in Philippine waters or distant water fishing, to ensure compliance with conservation and management measures, adopted by RFMOs and by DA. 10. Adopt an appropriate monitoring, control, surveillance and traceability system, for municipal fishing vessels supplying exporters with concurrence of the LGUs, and 11. Coordinate with LGUs and other concerned agencies, for the establishment of productivity-enhancing and market development programs in fishing communities, to enable women to engage in other fisheries and economics activities and contribute significantly to development efforts. What is the composition of BFAR? As a line bureau, the BFAR is headed by a director, and assisted by 2 assistant directors who shall supervise the administrative and technical services of the bureau, respectively. There shall be BFAR offices in the regional, provincial and municipal levels, as may be appropriate and necessary, to carry out effectively and efficiently the provisions of this code. Section 67 of the code is about fisheries inspection and quarantine service. For purposes of monitoring and regulating the importation and exportation of fish and fishery/aquatic resources, the Fisheries Inspection and Quarantine Service in the BFAR is hereby strengthened, and shall have the following functions. 1. Conduct fisheries quarantine and quality inspection, of all fish and fishery/aquatic products coming into and going out of the country, by air or water transport, to detect the presence of fish pests and diseases, and if found to harbor fish pests or diseases, shall be confiscated and disposed of in accordance with environmental standards and practices. 2. Implement international agreements and commitments on biosafety and biodiversity, and prevent the movement or trade of endemic fishery and aquatic resources, to ensure that the same are not taken out of the country. 3. Quarantine such aquatic animals and other fishery products, determined or suspected to be with fishery pests and diseases, and prevent the movement or trade from and or into the country of these products, so prohibited or regulated under existing laws, rules and regulations as well as international agreements of which the Philippines is a state party. 4. Examine all fish and fishery products coming into or going out of the country, which may be a source or medium of fish pests or diseases, and are regulated by existing fishery regulations, and ensure that the quality of fish import and export meet international standards. And 5. Document and authorize the movement or trade of fish and fishery products, when found free of fish pests or diseases, and collect necessary fees prescribed by law and regulations. What is FARMC? FARMC stands for Fisheries and Aquatic Resources Management Councils. This council is represented by fisherfolk organizations or cooperatives, and non-governmental organizations or NGO in the locality, and are assisted by the LGUs and other government entities. Before organizing FARMCs, the LGUs, NGO, fisherfolk, and other concerned people's organization, shall undergo consultation and orientation on the formation of FARMCs. There should be a FARMC on the national level, called the FARMC. FARMC is composed of 15 members, consisting of the Undersecretary of Agriculture, as chairman, the Undersecretary of the Interior and Local Government, 5 members representing the fisherfolk and fishworkers, 5 members representing commercial fishing, and aquaculture operators, and the processing sectors, 2 members from the academe, and 1 representative of NGOs involved in fisheries. The members of FARMC, except the Undersecretary of Agriculture and the Undersecretary of the Interior and Local Government, shall serve for a term of 3 years, without reappointment. What are the functions of the FARMC? The FARMC shall have the following functions. Assist in the formulation of national policies for the protection, sustainable development and management of fishery and aquatic resources for the approval of the Secretary, assist the Department in the preparation of the National Fisheries and Industry Development Plan, and perform such other functions as may be provided by law. Similarly, a FARMC is also created in each of the municipalities or cities, abutting municipal waters. The LGU may also create barangay FARMCs, and the lake-wide FARMCs, whenever necessary. Such BFARMCs and LFARMCs shall serve in an advisory capacity to the LGUs. What are the functions or MC FARMC? The MC FARMCs shall exercise the following functions. 1. Assist in the preparation of the Municipal Fishery Development Plan, and submit such plan to the Municipal Development Council. 2. Recommend the enactment of municipal fishery ordinances, to the Sangguniang Bayan or Panlungsod, through its Committee on Fisheries. 3. Assist in the enforcement of fishery laws, rules and regulations in municipal waters. 4. Advise the Sangguniang Bayan or Panlungsod, on fishery matters through its Committee on Fisheries, if such has been organized. And 5. Perform such other functions which may be assigned by the Sangguniang Bayan or Panlungsod. What is the composition of FARMC? The regular member of the M/FARMCs shall be composed of the following: the Municipal or City Planning Development Officer, the Chairperson, Agriculture or Fishery Committee of the Sangguniang Bayan/Panlungsod, a representative of the Municipal or City Development Councils, a representative from the accredited NGO, a representative from the private sector, a representative from the Department of Agriculture, and at least 11 fisherfolk representatives, of which 7 are municipal fisherfolks, 1 fish worker, and 3 commercial fishers in each municipality or city, which include representative from youth and women's sector. What are FARMC? In case of bays, gulf, lakes, and rivers and dams, bounded by 2 or municipalities or cities, an Integrated Fisheries and Aquatic Resources Management Council, or IFARMC, can be created. The IFARMC shall have the following functions. 1. Assist in the preparation of the Integrated Fishery Development Plan, and submit such plan to the concerned municipal development councils. 2. Recommend the enactment of integrated fishery ordinances, to the concerned Sangguniang Bayan or Panlungsod through its Committee of Fisheries, if such has been organized. 3. Assist in the enforcement of fishery laws, rules and regulations in concerned municipal waters. 4. Advise the concerned Sangguniang Bayan or Panlungsod on fishery matters, through its Committee on Fisheries, if such has been organized. And 5. Perform such other functions, which may be assigned by the concerned Sangguniang Bayan or Panlungsod. WHO comprise the IFARMC? The regular members of the IFARMC shall be composed of the following: the Chairperson of the Committee on Agriculture or Fisheries, of the concerned Sangguniang Bayan or Panlungsod, the Municipal or City Fisheries Officers, of the concerned municipalities/cities, the Municipal or City Development Officers, of the concerned municipalities/cities, 1 representative from NGO, 1 representative from private sector, and at least 9 representatives from the fisherfolk sector, which include representatives from the youth and women's sector. What does the Fisheries Code says about fish refuge and sanctuaries? The Department may establish fish refuge and sanctuaries, to be administered in the manner to be prescribed by the BFAR, at 25% to 40% of bays, foreshore lands, continental shelf or any fishing ground, which shall be set aside for the cultivation of mangroves to strengthen the habitat and the spawning grounds of fish. Within these areas, no commercial fishing shall be allowed. All marine fishery reserves, fish sanctuaries and mangrove swamp reservations, already declared or proclaimed by the President or legislated by the Congress of the Philippines, shall be continuously administered and supervised by the concerned agency. In municipal waters, the concerned LGU, in consultation with the FARMCs, may establish fishery refuge and sanctuaries. What does the Code says about NFRDI? In recognition of the important role of fisheries research in the development, management, conservation and protection of the country's fisheries and aquatic resources, National Fisheries Research and Development Institute or NFRDI. The Institute shall form part of the National Research and Development Network of the Department of Science and Technology or DOST. The Institute, which shall be attached to the department, shall serve as the primary research arm of the BFAR. The overall governance of the Institute shall be vested in the Governing Board, which shall formulate policy guidelines for its operation. The composition of the Governing Board shall be as follows: the Undersecretary for Fishery, which shall serve as Chairman. The BFAR Director, which shall serve as Vice Chairman. The members include the NFRD Executive Director, the PCAARRD Director General, a representative from the Academe, 4 representatives from the private sector who shall come from the following subsectors: Municipal Fisherfolk, Commercial Fishing Operator, Aquaculture Operator, and Post-Harvest/Processor. WHO shall head NFRDI. The institute shall be headed by an executive director, to be appointed by the President of the Philippines upon the recommendation of the governing board. The executive director shall hold a doctorate degree in fisheries and/or/other related disciplines. What are the researches and development objectives of NFRDI? Researches to be done by the NFRDI are expected to result in the following. 1. To raise the income of the fisherfolk, and to elevate the Philippines among the top 5 in the world ranking, in the fish productions. 2. To make the country's fishing industry in the high seas competitive. 3. To conduct social research on fisherfolk families, for a better understanding of their conditions and needs and 4. To coordinate with the fisheries schools, LGUs and private sectors regarding the maximum utilization of available technology, including the transfer of such technology to the industry, particularly the fisherfolk. What are the functions of NFRDI? As a national institute, the NFRDI shall have the following functions. Establish a national infrastructure unit, complete with technologically advanced features and modern scientific equipment, which shall facilitate, monitor, and implement various research needs and activities of the fisheries sector. Provide a venue for intensive training and development of human resources in the field of fisheries, a repository of all fisheries researches and scientific information. Provide intensive training and development of human resources, in the field of fisheries, for the maximum utilization of available technology. Hasten the realization of the economic potential of the fisheries sector, by maximizing developmental research efforts, in accordance with the requirements of the National Fisheries Conservation and Development Programs, also possibly through collaborate effort, with international institutions, and formally establish, strengthen and expand the network of fisheries researching communities, through effective communication linkages nationwide.